In today's video, we will talk about criminal evidence and the burden of proof. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice, or working in the legal or law enforcement fields, need to know about the different types of evidence used in criminal trials. We will also talk about presumptions, the burden of proof, and the concept of reasonable doubt. So let's jump right into criminal evidence and the burden of proof. There are initial presumptions in any criminal case. For example, the defendant is presumed innocent until proven guilty. In the American criminal justice system, the defendant is not required to prove that they're innocent. That is not the case in some other countries. In some countries, the defendant is supposed to prove their innocence. Well, that can be impossible to prove sometimes. Also, the defendant is presumed to be sane unless there is evidence of insanity. The burden of proof in criminal trials. The prosecutor has to prove every element of every charged offense beyond a reasonable doubt. If any of those elements are missing, the jury should not convict the person. The prosecutor has the burden of production, meaning they must produce the evidence they rely on in court, not merely say that the evidence exists somewhere. The jury needs to be able to see the evidence and examine it and ask questions about it. So the prosecutor must produce the evidence. Also, the jury has the burden of persuasion. The evidence they produce must be credible and strong enough that it persuades the jury. I would like to stress once more about proving every element of every charged offense beyond a reasonable doubt. Let's say that a trial involves 5 counts of attempted murder. Someone went into a gas station and Quickie Mart. They were armed. They were having a shootout with a rival gang, and they are afterward arrested and charged with attempted murder of 5 of the people in the gas station and parking lot. The prosecutor must prove every element of each of those 5 counts of attempted murder beyond a reasonable doubt. If they prove 3 of them in full, meaning each element of attempted murder beyond a reasonable doubt as to that individual, if the prosecutor proves every element, the jury can convict on that count. But if there's even one element missing from one of the attempted murder counts, the jury cannot convict on that count, but they still can convict on any of the other counts as long as the prosecutor proved every element of those other counts. Direct and circumstantial evidence in criminal trials. This tends to really throw a lot of students. So, let's discuss it. Direct evidence is evidence that directly establishes a fact. I looked out the window and I saw that it was raining. So my testimony in court would be, I looked out the window and saw it was raining. That would be my eyewitness account, and it would be direct evidence. Indirect evidence, also called circumstantial evidence, requires the jury to infer a fact. For example, I saw Bob come inside. He was soaking wet and carrying a dripping wet umbrella, so I assumed that it was raining. But at that time, I was in a room with no windows, and I had not looked out the window and to see the rain at any time. So this would be my testimony that I saw him come inside. He was soaking wet. He had a dripping wet umbrella. So I assumed that it was raining, even though I did not see that directly. That would be indirect evidence, also called circumstantial evidence. The main types of evidence in criminal cases include testimony, that is what witnesses say, real evidence, scientific evidence, and demonstrative evidence. Let's say that we're going back to the gas station attempted murder case. Types of evidence for that would be testimony of eyewitnesses who witnessed what happened. They were in the gas station or the parking lot on the day of the shooting. They saw it happen. They can testify, and that is direct evidence. Real evidence. Real evidence might be that the police confiscated the weapons, that they picked up bullet cartridges from the scene. Real evidence might be videotape footage from the gas station's security system. Scientific evidence could be ballistic reports matching the bullets found at the scene with the guns retrieved from the defendants. Demonstrative evidence is where one of the lawyers or witnesses creates evidence to use at trial to explain a concept to the judge and jury. Now, creating evidence is not a bad thing as long as it is not faked or fraudulent. For example, useful direct evidence might be if they have an easel in the courtroom with a huge pad of paper on it, and they are given markers and asked to draw the scene, the outline of the parking lot and the building where they were at the time that the shooting started and where the defendants were and the victims were. That would be demonstrative evidence, and it would help the jury and the judge to visualize what happened. Admissibility of evidence. Evidence must be trustworthy to be admissible. There are also other requirements, but it must be trustworthy. Hearsay is usually not admissible, although there are many exceptions to the hearsay rule, and then there are exceptions to the hearsay rule. In an evidence class, you might go into more detail on those, but trust me, it could make your head spin. So the hearsay rule is basically a witness cannot walk into court and testify that someone's told them something, generally, because that's hearsay. The lawyers and judge should have the opportunity to question and to cross-examine the person who originally said the statement. They can't do that if they're not the one in court testifying. So that would be the hearsay rule. It's also commonly referred to as he said, she said. The best evidence rule is that you're not allowed to put on evidence that is not considered the best evidence for that issue. A witness would not be allowed, for example, to testify as to how much their electric bill was in July of 3 years ago, because the best evidence of that fact would be if one of the lawyers had obtained a copy of the actual bill and had it certified as being authentic and accurate. The best evidence would be required. It keeps lawyers from getting sloppy. Also, the evidence must be credible. It must be believable. Sometimes people will spin unbelievable nonsense when they're sitting in the witness chair at court. The judge doesn't believe them, their own lawyer doesn't believe them, the jury doesn't believe them. If it's not credible, it's not going to be useful at court. Also, relevance. It must be relevant to the case at issue. If it is not, a lawyer can object and the judge might grant or sustain that objection. And for scientific evidence to be admissible at court, most courts follow what they call the general acceptance test, which means that if the scientific evidence is generally accepted by the scientific community as valid and legitimate, the court will let it in. But if it's some fringe thing that basically involves the equivalent of sacrificing a chicken to try to tell the future, that would not pass the general acceptance test. So it would not be admissible in court. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results, and the higher these videos are in the results, the more people I can help. Thank you. Forensic science evidence. In criminal cases, forensic science can include such things as blood, DNA, fingerprints, firearms, and ballistics, and the test results or reports involving any or all of those items. There is also junk science or pseudoscience. We hit on those briefly a few minutes ago. The forensic science field has many types of fringe pseudoscience tests and procedures that are trying to worm their way into court frequently, and if it is not legitimate as generally accepted by the scientific community, it's usually not going to come in. And that's because, especially in criminal law, we don't want people convicted on things that are not scientifically valid. And let's touch briefly on what's called the CSI effect. The CSI effect is because there's so many crime shows on TV, and many of them involve very expensive forensic testing. Juries now expect that to be the case in real life. The fact of the matter is, neither the prosecution nor the defense has the kind of budget that TV shows do. And if a case, for example, involves an issue of a person being accused of defrauding someone of $5,000, their defense lawyer or the prosecutor is unlikely to spend $50,000 getting forensic evidence for the case. But the problem is the juries will find a defendant not guilty if the prosecution does not have the kind of impressive and expensive forensic evidence that they've seen used on TV shows. And that's unfortunate. And finally, about admission of evidence. If either side is going to object to the admission of evidence at trial, those objections must be made timely, often before trial, to give the lawyers time to argue the issue before the judge and out of the sight and hearing of the jury. And they don't want to have to take the jury time to fight those battles. Those should be resolved before trial. The use of inadmissible evidence in court can lead to a mistrial, even if the judge instructs the jury to disregard the challenged evidence. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video called Steps in a Criminal Trial.